When an employee files a complaint at work, the company has a responsibility to look into it. But what happens when the so called investigation isn't real and instead feels like retaliation? That's exactly what Stacie Culp and Stephanie Peters say happened to them when they worked at Remington of Montrose Golf Club in Colorado. The employees made some very serious allegations, but instead of accountability, real accountability, they faced a fake investigation, retaliation, and were ultimately pushed out of their jobs. So, by the end of this video, you will understand what a real investigation at work should look like, the red flags that an investigation might be fake or at least error prone, and the risk companies face when they mishandle investigations. Hi, I'm Harlow Reed, employment lawyer, HR consultant, and creator of the HR Insider. On this channel, I do more than share my legal opinion. I break down real legal cases to show how the law might apply to your situation. Okay, so when an employee files a complaint, when they are complaining about discrimination or harassment, most companies will carry out some kind of investigation. And investigating a complaint gives the employer a chance to address the problem that's been brought to their attention. And it also gives them a chance to protect themselves legally if they take quick corrective action, that is. And for employees, filing a complaint at work, it's very terrifying for many people, not just because of the misconduct itself, but because employees don't know what to expect next. And the truth is, a lot of small employers don't know what they're supposed to do either. They don't realize they can be held legally responsible if they mishandle the process. But here's the big question: what if the employee feels like the investigation that was done is just for show? It's rushed, it's half hearted, or completely inadequate. It can leave so many feeling like the company is responding just to protect themselves instead of doing the right thing or protecting the victim. If you want to know more about how investigations can go wrong and what warning signs to watch out for, be sure to check out my other videos: Workplace Investigations Gone Wrong, What Happens When Employers Mess Up. Another video that I did on this channel that covers investigations is entitled She Had 5 Pages of Evidence, but It Wasn't Enough. Both of these videos shed even more light about employee rights and what employers are actually obligated to do when a complaint is made. Because let's face it, when you understand how the process is supposed to work, you're in a much stronger position to protect yourself. Okay, let's talk about it. The content shared on this channel is for informational purposes only and shouldn't be taken as legal advice. Always consult a qualified attorney or HR professional for guidance on your specific situation. And hey, don't forget to like and subscribe. This case starts with Stacie Culp and Stephanie Peters, who both began working as servers at Remington in June 2017. Remington operates a golf club and casual dining restaurant in Montrose, Colorado. Stacie Culp and Stephanie Peters were both servers at Remington's restaurant. Jason DeSilva was also employed by Remington as a bartender and an assistant floor manager at the restaurant. Stephanie Peters and Stacie Culp both alleged that they were sexually harassed by Jason DeSalvo. But at first, neither of them reported it. Stephanie Peters warned Stacie Culp that management at Remington had a history of brushing off complaints about bullying and harassment. So Stacie Peters was worried that if she spoke up, nothing would happen. So instead of reporting it, she quietly started looking for another job. And by late July, she applied to go back to work at her old position at Applebee's. During the interview with Applebee's, when a manager asked why she wanted to leave Remington, Stacie mentioned that she had been experiencing sexual harassment at Remington. Well, news travels fast, and that allegation made its way back to Remington management, to the management team. And soon after that, Remington's general manager, Eric Feely, the food and beverage manager, Rick Crippen, and the HR marketing director, Beth Feely — yes, there's a family connection there — they pulled Stacie aside during her shift to talk to her about what she said during her interview at Applebee's. And that's when Stacie revealed what she had experienced at Remington. She told them about the harassment, and she even wrote a quick statement on a scrap piece of paper about her experience. And from there, Remington opened what they called an investigation, led by Eric Feely and Beth Feely themselves. Now, they were working with an employment lawyer who recommended a thorough investigation, but Eric Feely decided only to interview 10 of the female servers and just asked two questions, which were: is there anything appropriate around Jason DeSalvo that you want to share? And the second question was: is there anything you'd like to add? That was it. They didn't specifically ask anyone if they had witnessed anything involving Stacie Culp, and no one followed up even when employees brought up concerning behavior during the interview. One server they spoke to said Jason DeSalvo talked about other employees' bodies and had driven one female employee to quit. And another waitress admitted she'd heard about Jason DeSalvo touching others inappropriately. Stephanie Peters herself said Jason DeSalvo had invited her and another employee over to his house for drinks and had sexually harassed other employees and had also been verbally sexual even with underage girls who were visibly uncomfortable. Despite all of this, there were no follow up interviews. Eric Feely later said he thought a lot of what Stacie reported was false. And so, after wrapping up their investigation, Remington suspended Jason DeSalvo for just 5 days without pay, also demoted him from assistant floor manager to bartender, and put him on a 30-day probationary period. Management explained to Jason DeSalvo that during probation, there couldn't be any valid documented complaints from coworkers or customers, as if the burden somehow shifted to others to catch him in the act again. And after this so called investigation ended, things only got worse. Stacie Culp's hours were cut, she was feeling pushed out, so she resigned not long after. Meanwhile, Stephanie Peters didn't feel like her complaint was ever properly investigated at all, and when Jason DeSalvo returned from his suspension, according to Stephanie, he retaliated against her. He refused to fill her drink orders, he cursed at her, and he even shoved her at one point. Stephanie went straight to Eric Feely's office to complain, and according to Stephanie, Eric Feely took one look at her and said, "Gosh, Steph, do we have to do this every week?" And that comment for Stephanie was the last straw. She walked out immediately and never returned to Remington. And on August 19th, 2021, Stephanie Peters and Stacie Culp officially filed a lawsuit against Remington of Montrose Golf Club in the U.S. District Court for the District of Colorado. They brought three claims against Remington. First, hostile work environment based on sexual harassment. Second, retaliation for speaking up about that harassment. And third, something called negligent supervision and retention, which basically means they were arguing that Remington knew or should have known about Jason DeSalvo's behavior and failed to take action to protect employees. And in response, Remington did what a lot of companies do when they get sued. They filed for something called summary judgment. And all that means is that they asked the judge to throw out the case without even letting it go to trial. They argued that the plaintiffs did not have a valid claim for the court to consider. And the judge partially agreed. They dismissed Stephanie Peters' retaliation claim, but let everything else move forward. And this is where things started to get messy. When the case finally went to trial, the jury made some very confusing decisions. They awarded Stacie Culp punitive damages, meaning they believed Remington's behavior was bad enough to deserve punishment. But at the same time, they found that Remington didn't actually violate Stacie's rights under the law, which doesn't make a lot of sense. Normally, you can't award punitive damages unless you find a legal violation. So that decision was appealed by Stephanie Peterson, and the U.S. 10th District Court of Appeals ruled that the jury's verdicts were legally inconsistent, and they sent the case back for a new trial. But when the case went back to the lower court for a new trial, the ruling by the U.S. 10th Circuit Court of Appeals made something very clear. Even though Stephanie Peters claimed the investigation was half hearted, she wasn't able to prove that the poor investigation actually caused her any measurable harm. But if Stephanie had been able to show that the half hearted investigation actually caused her real harm, Remington could have been held liable for that. And that's more important because when companies investigate misconduct, whether it's discrimination, harassment, or anything else, they can't just go through the motions. A real investigation has to be thorough, it has to be fair, and it has to demonstrate that it was taken seriously, the complaint was taken seriously. Otherwise, it can open the door to even more legal trouble. Employers need to ask real open ended questions, and they also need to drill down into the specifics of the behavior that's being reported. A good investigation always starts with the basics: who, what, when, where, and how. But it can't stop there. Investigators have to gather information from all relevant witnesses. And just as importantly, they have to follow up when something concerning is brought to their attention. If someone mentions a new incident or inappropriate behavior during the interview, the employer has to go deeper, not just move on. Because at the end of the day, the goal is to get the whole story so that they can make an informed, objective decision and take the right action. This case is such a powerful reminder that a real investigation isn't just asking two questions. It means taking allegations seriously. It means digging into facts, not brushing them aside. And it means protecting employees, not punishing them. So, if you're facing a workplace investigation or you're involved in conducting one, remember a bad investigation can cause just as much harm as the misconduct itself. Thanks for watching. If you found this breakdown helpful, don't forget to like, subscribe, and check out my other videos on workplace investigations, retaliation, and how to protect yourself at work.